Today we are breaking down a critical Supreme Court judgment, one that puts some very clear limits on one of the most powerful and, I'd argue, most debated tools in the entire POCSO Act, the presumption of guilt under Section 29. In cases like these, the line between protecting a child and presuming someone's guilt can get incredibly blurry. This Supreme Court case draws that line with almost surgical precision, and honestly, it's a masterclass in evidence and due process. So let's get right into it. The case we're focusing on is Debraj Dutta versus the State of West Bengal. And it's a big one, because it clarifies the incredibly high bar the prosecution has to clear before that powerful presumption of guilt can ever be brought into play. I'm your host, Advocate Ravi Kumar from KanoonPlus. And hey, before we really get into the weeds of this judgment, make sure you're subscribed. We deliver the most sophisticated legal breakdowns you're going to find anywhere in the country. We go deeper. Okay, to really get what the Supreme Court did here, you first have to understand the immense power of the legal tool that's at the very heart of this case. So here it is. Section 29 of the POCSO Act. It creates what's called a presumption of a culpable mental state. In plain English, once the prosecution establishes the basic facts of the crime, the law says the court shall presume the accused is guilty. Just like that, the entire burden of proof flips. It's no longer on the prosecution to prove guilt, it's now on the accused to prove their own innocence. It is an incredibly powerful weapon, but as we're about to see, it's a conditional one. And the journey of this case really shows you the legal tug-of-war that was going on. So the accused, Debraj Dutta, was actually acquitted by the trial court back in March 2019. But then the High Court stepped in, reversed that decision, and convicted him, relying heavily on that very Section 29. And that reversal? Well, that's what set the stage for the Supreme Court's definitive intervention. So this brings us right to the heart of the Supreme Court's reasoning. Where exactly did the High Court go wrong? Well, the answer lies in a concept called the foundational fact. This is the key difference right here. The High Court basically took the victim's statement and immediately pulled the trigger on the Section 29 presumption. The Supreme Court, on the other hand, slammed on the brakes. They said, whoa, not so fast. They mandated that the prosecution must first prove a foundational fact with solid, credible evidence before that presumption can even enter the picture. The Supreme Court basically laid out that Section 29 isn't some automatic light switch you can just flip. No, it's a very structured, three-step process. First, the prosecution has to prove the basic foundational facts of the alleged assault. Step 2, and this is absolutely crucial, the evidence for those facts, especially the child's testimony, has to be, and I'm quoting here, fully credible and trustworthy. It's only after you clear both of those hurdles that the burden finally shifts to the accused. And this quote from the judgment says it all, doesn't it? It's the new bedrock for these cases. You simply cannot build a legal presumption on a shaky foundation if the victim's testimony itself has serious holes. You can't just ignore them and use that same testimony to trigger a reverse burden of proof. It just doesn't work that way. So how did this play out in the real world in this specific case? Let's take a hard look at the evidence, or really the lack thereof, that led the Supreme Court to its decision. So this is the million-dollar question, isn't it? Where exactly did the prosecution's case fall apart and fail this newly clarified credibility test? The Supreme Court was remarkably clear about it. Here it is. A checklist of what the court called fatal discrepancies. First off, a huge unexplained delay, almost an entire day in filing the FIR. And what makes that especially weird is that the victim's father was a police officer. You'd think he'd know the importance of timely reporting. Second, the mother actually refused a medical exam, even a simple non-invasive one. The court took one look at that and drew an adverse inference. Third, there was a major inconsistency in the victim's own testimony. A key detail she told her mother about the accused, allegedly brushing his leg against hers, completely disappeared when she was in court. And finally, you had another witness, PW6, whose testimony suggested another student was right there, which completely contradicted the victim's story of being alone with the accused. When you put all that together, the case just crumbles. Now this is a really critical point for any legal professional watching. I mean it. Share this specific segment with your colleagues. This checklist is a textbook example of how to deconstruct a prosecution's case and effectively challenge a POCSO conviction when the foundational facts are just not there. This all leads us to the final ruling and the powerful message it sends about the balance between protective laws and the fundamental principles of our justice system. The outcome was clear and decisive. The Supreme Court allowed the appeal, completely set aside the High Court's conviction, and restored the original trial court judgment. The acquittal stood. And the final word from the court was this: the High Court was simply not justified in what it did. And why? Because at its core, the prosecution had failed to prove the guilt of the appellant beyond a reasonable doubt. The presumption under Section 29 couldn't be used as a band-aid to fix a fundamentally flawed case. And so this leaves us with a really provocative question. One I want you to think about as legal minds. What's your take? Do you think the court managed to strike the right balance here between the absolute necessity of protecting children and safeguarding the due process rights of an accused person? Or has the bar for proving that foundational fact now been set so high that it might actually make future convictions more difficult? I really want to hear your analysis on this. Join the conversation down in the comments. And for a full breakdown of this case and so much more, make sure you're subscribed to KanoonPlus and visit us at noonplus.com. Like and share this explainer, and let's move the legal conversation forward
Friends,
together.
Don't forget to share your views in the comment box and subscribe to KanoonPlus channel.